The Labour Party's final address is meticulous and comprehensive, addressing various aspects of the election. Let's begin with their response to the election results. In their final address, the Labour Party stated that they conducted data analysis for the 18,088 polling units with blurred results on iRev, revealing 2,565,269 accredited voters. Upon further investigation, they found that 9,165,191 voters collected their PVCs in these units, resulting in a higher number of accredited voters than the margin between Tinubu and Peter Obi. Although it is possible that not all accredited voters in these 18,000 polling units voted for a single candidate, the lack of specific numbers renders the announced results invalid. Moreover, other votes by INEC remain unaccounted for. The data analysis provided by the Labour Party's unchallenged witness reveals that 39,546 polling units were inaccessible on iRev, with 23,119,298 registered voters having collected their PVCs and 5,532,553 voters accredited on election day in these units. When combining this figure with the previously unaccounted 2.5 million votes, the unaccounted votes exceed 8 million. This discrepancy is significantly high when considering the margin between Tinubu and Peter Obi based on INEC's allocated figures. The Labour Party's legal team argues that this indicates massive voter suppression by INEC, suggesting that the election should not have been called without accounting for all votes, particularly when the unaccounted votes surpass the margin between candidates. INEC has previously declared some governorship elections inconclusive due to unresolved and unaccounted votes exceeding the margin of lead, raising questions as to why a similar approach was not taken during the presidential election. The Labour Party's legal team also highlights the lack of sufficient evidence provided by INEC, as they failed to present hard copies representing the blurred and inaccessible results. The Labour Party challenges INEC's certification of blurred iRev copies, which are unreadable and even contain images unrelated to the election. They question why, in the absence of hard copies from INEC, the court should not invoke the presumption of Section 167 subsection D of the Evidence Act in their favor. The legal team cites a Supreme Court judgment between Danladi and Dangiri 2015, where the court held that if an admitted document is incomplete, the party to be affected is the one who should have produced the proper, correct, and complete document, but failed to do so. Based on this precedent, the Labour Party urges the court to consider the 18,088 blurred copies as the actual results of the election. Additionally, the Labour Party argues that the alleged technological glitch on the day of the election does not justify the outright violation of the Electoral Act, INEC regulations, guidelines, and the manual for election officials. The election laws unequivocally require the immediate upload of Forms EC8 as to iRev from the polling units right after vote counting. However, in its final address, INEC claimed that a previous federal high court judgment in the case against the Labour Party allowed them the discretion to conduct elections and collate results as they deemed fit. The Labour Party's legal team refuted this claim, asserting that the High Court's judgment was of lower authority compared to the Supreme Court's ruling in Oyetola versus INEC. Additionally, the Labour Party countered INEC's argument that its guidelines and regulations are merely ordinary documents. They cited the Supreme Court's precedent in Falej versus INEC, where it was established that the Manual for Election Officials holds the force of law as a subsidiary legislation, deriving its authority from the Constitution and Electoral Act. The Labour Party emphasized that even INEC's guidelines themselves acknowledge the mandatory nature of uploading results. This electronic transmission of results ensures transparency and addresses irregularities that may occur between polling units and collation centers, such as result hijacking, exchange, or destruction. It is evident that INEC's commitment to transparent results management is supported by specific sections of the Electoral Act 2022, which confer INEC with the power to transmit election results electronically. By adopting this system, the occurrence of human errors and delays in results collation is minimized, while enhancing the overall accuracy, transparency, and credibility of the process. Given these undeniable aspects, the Labour Party questioned how INEC could overlook the mandatory nature of result uploading and claimed that failure to upload did not impact the results. The Labour Party's legal team further pointed to Section 60 of the Electoral Act 2022, which not only makes it mandatory to upload results, but also provides penalties, including imprisonment or fines, for presiding officers who fail to adhere to this requirement. Furthermore, the Labour Party presented evidence from a cybersecurity expert who attested that INEC's IT infrastructure for the election was inadequately tested and exposed to vulnerabilities. They argued that INEC's failure to comply with standard guidelines for government websites further supported their claim of non-compliance. Relying on Section 167, subsection D of the Evidence Act, the Labour Party contended that this evidence substantiated substantial non-compliance by INEC, which had a profound impact on the outcome of the presidential election. The party also highlighted a mathematician's data analysis, demonstrating that the Labour Party emerged victorious in Rivers and Benue states. This analysis was based on Forms EC8 as uploaded on iRev and certified copies of Forms EC8 as given to the Labour Party by INEC. According to this unchallenged report, the Labour Party would gain 2 states, while the APC would lose 2 states in the final tally. As a result, the Labour Party urged the court to nullify the presidential election in the pursuit of justice and to declare the purported return of Tinubu invalid. In light of the Labour Party's strategy, their legal team intentionally refrained from submitting the total computed figures of their election score. This strategic move was intended to avoid the contradiction of claiming victory in a seriously flawed election while simultaneously seeking its nullification due to gross violations of the Electoral Act. The Labour Party acknowledged this aspect in their petition, but expressed the hope that, should the court determine that the violations did not significantly affect the results, a recollection of votes would be warranted. Essentially, the Labour Party aimed to present the evidence of their victory without adopting an inconsistent stance on the election's validity. The ultimate decision now rests with the court, and a more detailed analysis will be better suited for a separate video presentation. Before delving into their response regarding the 25% requirement in Abuja, let's first explore how they countered INEC's argument that they are not bound by their pre-election statements. As you may recall, INEC claims that a court judgment permits them to conduct elections as they please, allowing them to announce one approach before the election and then act differently during the election without facing consequences. However, the Labour Party vehemently disagrees with this notion and poses a question to the judges. Has INEC not publicly represented and assured that it was firmly committed to complying with the law by electronically transmitting and uploading election results from polling units to the iRev portal? Is INEC not disturbed by reneging on this publicly given assurance? To establish the principle of estoppel, the Labour Party cites the Supreme Court judgment in the matter between Access Bank and NSITF 2022, which emphasized that estoppel is more than just a rule of practice. It is a substantive rule of law. The essence is that a person should not be allowed to take contradictory positions, to affirm one thing at one time and deny it at another, commonly known as to approbate and reprobate. The Labour Party asserts that INEC cannot simply claim the right to contradict their previous statements, particularly after assuring the nation, both in Nigeria and even internationally at Chatham House in London, that they would transmit and upload polling unit results on election day, only to act in opposition to their declaration, and believe they are within their rights to do so. They further draw attention to statements made by people like Festus Okoye, who repeatedly emphasized before the election that INEC would not abandon the upload of election results. In a recent interview, Okoye's statements were allegedly denied by an INEC representative who appeared in court under subpoena, stating that the press release in question does not exist in their records. The Labour Party, however, managed to download the press release from INEC's website and presented it in court as evidence. Additionally, the Labour Party cites the recent Supreme Court judgment on Oyetola versus Adeleke, which reinforced the mandatory requirement for the upload of results from polling units. regarding the arguments put forth by Tinubu's counsel in their final address, claiming that the petitioners are inviting anarchy by raising the issue of non-electronic transmission of results by INEC. The Labour Party dismisses it as a baseless and destructive blackmail aimed at undermining the country's judicial and constitutional framework. The Labour Party sees no issue in petitioners raising valid concerns to challenge an election, and they consider such claims of inviting anarchy as an extreme and dangerous interpretation of the situation. Let's take a look at how the Labour Party's legal team addressed the 25% requirement in Abuja. Recall that Tinubu's counsel initially argued against it, but eventually agreed that the "and" in the provision is conjunctive. However, in their new reply, they claimed that it's 25% of 2/3 of the votes cast in Abuja. The Labour Party legal team finds this contradictory and questions why Abuja would be treated differently from the states in this regard. To counter the argument, the Labour Party cited a Supreme Court judgment from 2022 in the case between FRN versus Nganjiwa, which upheld the importance of literal interpretation where the words of the Constitution are clear and unambiguous. They argued that the words "and the Federal Capital Territory" in Section 134, subsection 2 of the Constitution should be read together with Section 299. The Labour Party contended that Section 299, stating that Abuja should be treated as a state, pertains to the exercise of executive, legislative, and judicial powers in Abuja. They provided judicial precedents to support the interpretation that Abuja's status as a state relates to its governance structure and not to the presidential election's 25% requirement. Furthermore, they pointed out that the specific mention of each in the states of the Federation implies exclusivity, as illustrated in a judicial precedent between Grant Systems Petroleum Limited versus Access Bank plc in 2015. They emphasized that Section 134, subsection 2b, with the conjunctive use of "and," makes the 25% requirement in Abuja mandatory, along with the 25% requirement in the states. Regarding the use of the word "and," they referred to the judicial precedent in Abubakar versus Yar'Adua in 2008. The Labour Party argued that the drafters of the Constitution deliberately amended Section 299 in the 1999 Constitution to include the 25% requirement in Abuja, indicating their intention for the popularity of the winning candidate to extend to the capital city, which represents all Nigerians and truly reflects their will. They further pointed out that Section 299, treating Abuja as a state, is a general provision and doesn't impact the specific requirement of Section 134, subsection 2b. They argued that interpreting Section 134, subsection 3b should be done in conjunction with Section 14 of the Constitution, emphasizing that sovereignty belongs to the people of Nigeria, and elections must reflect their will. In conclusion, the Labour Party urged the court to dismiss the respondents' defense as lacking any merit and to consider the petitioners' case as meritorious, granting them their requested reliefs. Let's now examine their response to Tinubu's forfeiture. Tinubu's legal counsel initially claimed that the forfeiture judgment was not registered in Nigeria and therefore cannot apply in the country. However, the Labour Party's legal team countered this argument by asserting that the judgment, being documentary evidence, is certified, sealed, notarized, and authenticated by the United States court that issued it. To back up their claim, they referred to a judicial precedent delivered by the Supreme Court in 2004, the case of MV Delos versus Ocean Steamship Nigeria Limited. The court held that a party relying on the judgment of a foreign court must comply with either of two options: A, seal the judgment with the seal of the foreign court, or B, provide a copy certified by the legal keeper with a certificate of a notary public or diplomatic agent, stating that the copy is duly certified by the officer. The Labour Party argued that the judgment against Tinubu, which they tendered in evidence, met all the relevant conditions. The Labour Party also debunked Tinubu's legal team's claim that the judgment must be registered in Nigeria. They pointed out that they are not seeking to enforce any money judgment against Tinubu, nor are they trying to recover any money payable under a foreign judgment, rendering the reciprocal enforcement of foreign judgments ordinance inapplicable in this case. Regarding the citation of Article 54, subsection 1C of the United Nations Convention Against Corruption by the respondents, the Labour Party's legal team argued that the article pertains to member states providing mutual legal assistance concerning property acquired or involved in the commission of an offense established in accordance with the convention. They asserted that Tinubu's judgment has nothing to do with mutual assistance, making the UN article cited by the respondents irrelevant to Peter Obi's petition. The main issue, as they claimed, is whether civil forfeiture under U.S. law, as ordered by the U.S. court in Chicago, can be equated to a fine as used in Section 137, subsection 1D of the 1999 Constitution. To support this claim, they cited the judicial precedent in the U.S. case of Austin versus United States in 1993, where the U.S. Supreme Court held that forfeiture is indeed a fine and a form of punishment, even if it did not follow from a criminal conviction. The court also held that the U.S. Congress used the word forfeit for fine. They further cited the U.S. Supreme Court judgment in Timms versus Indiana in 2019, where the court held that fines may be employed by the state for purposes other than retribution and deterrence, such as a source of revenue. The Labour Party's legal team contended that all the judicial precedents they cited consistently defined forfeiture as a fine or a punitive economic sanction against the persons whose property is affected. They highlighted that Tinubu did not challenge the forfeiture of the $460,000 narcotics proceeds, just like the individual in the Timms versus Indiana case challenged the forfeiture of his SUV. They argued that both suffered economic sanctions, and hence, forfeiture equates to a fine. Furthermore, the Labour Party cited the Administration of Criminal Justice Act 2015, which interprets a fine to include any pecuniary forfeiture or pecuniary compensation recoverable under an order. They also emphasized that Section 137, subsection 1D of the 1999 Constitution disqualifies a candidate if he has been fined by a court, and in all the cases they cited, whether civil or criminal, it is still considered a fine. The Labour Party's legal team pointed out that the Supreme Court in Nigeria has also defined forfeiture as a fine, referring to the cases of Attorney General Bendel State versus Abufoto in 1999 and Muhammad Abacha versus the Federal Republic of Nigeria in 2014. They argued that the express meaning and intent of Section 137, subsection 1D, is that a person who, even though not convicted, has forfeited property on account of criminal conduct should not be allowed to occupy the exalted office of President of Nigeria. In conclusion, the Labour Party's legal team maintained that the term all is used twice in Section 137, subsection 1D to separate persons convicted from persons who, even though not sentenced, are affected by an order of a fine imposed by a court. They reiterated that this particular section targets people fined by the court, like Tinubu, and even if they are not convicted, they still fall foul of this section. In this same section, the term any court was used. So the United States District Court, Northern District of Illinois, which issued the order of the fine against Tinubu, falls into the category of any court. Some may argue that the drafters meant a Nigerian court, but the Labour Party legal team contends that it refers to any court, and the use of all to separate them makes it evident. Tinubu, who opened a bank account with the same address that the U.S. Customs Service disclosed as a drop-off point for packages containing narcotics from Nigeria, is involved in actions that border on money laundering and narcotics trafficking. These actions fall under dishonesty and fraud, which disqualify a candidate under the Constitution. Regarding the witness they called, the Labour Party legal team points out that the fact he accepted that it was not a money judgment means that registering the judgment is not required in Nigeria, contrary to the respondent's claim. The witness's claim of having a license to practice federal law across the United States is deemed fictional, and his misunderstanding of American law, stating that the court relied on American law section 981 dealing with civil forfeiture, is embarrassing and undermines his claim of being knowledgeable in American law. Based on all these arguments, they request the court to hold that Tinubu was not qualified to contest the presidential election and should be disqualified. The arguments on the double nomination of Shettima will be addressed in another video.